All right, all right, all right. Peace, everyone. Yusef here. Today, real quick, I'm going to go through a case on right to travel. I don't understand why there is such a big discussion about right to travel. This appears to me to be a situation where people are just basically publicly demonstrating that they don't have very good comprehension skills and very good reading skills as it relates to these cases. So I'm going to go over a Supreme Court case, Hendrick versus Maryland, what the Supreme Court has said on the situation. It doesn't matter what any of you say out in the echo chambers. This is what the Supreme Court has said about it. And these are cases that you quote. And I don't understand why you're quoting them because they don't say what you think that they're saying. So Thompson versus Smith and Hendricks versus Maryland. These are like the two star cases that everybody likes to quote that says that you have a right to travel. So let's take some time to look at that and let's see whether or not these cases actually demonstrate whether you have a right to travel. And we're going to walk through it very slowly so people can understand what these cases actually say. Okay, so right here, oops, what happened? I just clicked off of it. Okay, there it goes. Okay, so right here we have Hendricks versus Maryland. I'm going to read this case for you. It's not a long decision, but I'm going to read it very slowly, and I'm going to go line by line to make sure that everybody understands what this case is saying. Okay, this is Hendrick versus Maryland, volume 235, U.S. Reporter, page 610. The year of publication is 1915. So it goes, it says, the movement of motor vehicles over highways being intended by constant and serious dangers to the public and also being abnormally destructive to the highways is the proper subject of police regulation by the state. So where here they're talking about how dangerous cars are and how cars destroy put wear and tear on the roads. So this is a proper subject of police regulation and the police powers of the state. I don't understand how anybody could misinterpret this. This is very clear what these people are saying. Very first line out the gate. Okay, it is the proper subject of police regulation. In the absence of national legislation covering the subject, a state may prescribe uniform regulations necessary for safety and order in respect to operation of motor vehicles on its highways, including those moving in interstate commerce. It doesn't say just cars moving in interstate commerce, in addition to cars moving in interstate commerce, that the state, in the absence of a national, meaning there aren't any national laws about traveling or driving an automobile or operating a motor vehicle or utilizing a conveyance, however you want to style it, it doesn't matter. Okay, that is the proper subject for police regulation. All right. A reasonable graduated license fee on motor vehicles when imposed on those engaged in interstate commerce does not constitute a direct and material burden on such commerce and render the act imposing such fee void under the Commerce Clause of the federal Constitution. Here, they're just talking about interstate commerce. All right. Why? Because the government, they control interstate commerce and anything that materially affects interstate commerce. Okay, they have authority over. So right here, the Supreme Court is saying that, hey, requiring a license doesn't affect interstate commerce. All right, so the federal government, this is their way of saying we're going to stay out of it. This is a state matter. It's not a federal matter. That's what that paragraph is talking about. It says a state may require registration of motor vehicles and a reasonable license fee is not unconstitutional as denial of equal protection of the laws because graduated according to the horsepower of the engine. Such a classification is reasonable. And on the back of license to this day, they classify the different automobiles. How many axles do you have? Is it a truck? Is it a car? All these different things. They classify these vehicles, and you have to pay a tax or a license fee a registration fee for the use of the roads. Registration is for the use of the roads. That's what you're paying for because they have to repair the roads. All right. And there's wear and tear on the roads. I'm in Dallas right now. The roads are horrible and they're fixing the roads right now. So everybody has to pay for their use of the public roads. That's what the registration is for. Not to tie you into some jurisdiction or something like that. They already have jurisdiction by just the simple fact that you are on the roads. But in using those roads, they want you to pay your fair share for the utilization of those roads. That's what it's for. A state which, at its own expense, furnishes special facilities for the use of those engaged in interstate and intrastate commerce may exact compensation therefor, and if the charges are reasonable and uniform, they constitute no burden on interstate commerce. In other words, they're not infringing on anything federal, okay? And they can furnish special facilities for the use of those engaged in interstate, that's the government, and intrastate, that's the state, commerce, all right? The action of the state in such respect must be treated as correct unless the contrary is made to appear. A state motor vehicle law imposing reasonable license fees on motors, including those of non-residents, does not interfere with rights of citizens of the United States to pass through the state. Crandall versus Nevada. The facts which involve the construction and constitutionality of certain provisions of the Motor Vehicle Law of Maryland and their application to citizens of the District of Columbia are stated in the opinion. Mr. Justice Reynolds delivered the opinion of the court. Plaintiff in error was tried before Justice of the Peace, Prince George's County, Maryland, upon a charge of violating the motor vehicle law. A written motion to quash the warrant because of conflict between the statute and the Constitution of the United States was denied. He was found guilty and fined. Thereupon, an appeal, and this man, he tried to say that the motor vehicle laws violated the Constitution, much of what y'all are saying today. All right, somebody made this challenge in 1915, the very same thing you are saying today. All right, and they denied it. They said a written motion to quash the warrant because of conflict between the statute and the Constitution of the United States was denied. He was found guilty and fined. Thereupon, an appeal was taken to the circuit court, the highest in the state having jurisdiction, where the cause stood for trial de novo. De novo means anew. They mean they're going to look at it and retry the whole thing from the beginning. Up on the original papers, it was there submitted for determination by the court upon an agreed statement of facts grievously verbose, but in substance as follows. All right, it was very wordy. Verbose means they had a lot of language in it, but they're going to just condense it for us. And what it was said is that the cause was originally brought July 27, 1910, before Justice of the Peace for Prince George's County by the state against John T. Hendrick for violating subsection 133 of the Motor Vehicle Law, effective July 1st, 1910. He is and then was a citizen of the United States, resident in Cormorant in the District of Columbia. On that day, he left his office in Washington in his own automobile and drove it to Prince George's County, and while temporarily there, was arrested on the charge of operating in it upon the highways without having procured the certificate of registration required by subsection 133 of the Motor Vehicle Law. He was brought before Justice of the Peace and fined $15 after having been found guilty of the charge set out in a warrant duly issued. A motion to quash having been denied, whereupon he filed his appeal. At the time and place aforesaid, he had not procured the certificate of registration for his automobile required by subsection 133. He still didn't go get his registration. Upon the foregoing, the court shall determine the question and differences between the parties and render judgment according as their rights in law may appear in the same manner as if the facts aforesaid were proven upon trial. Either party may appeal. In other words, we're reviewing this de novo. Either party, if you can look at this just like if it was on the lower court, and if you want to appeal our decision, you can. Okay? So it goes on. The Maryland legislature, by an act effective July 1st, 1910, prescribed a comprehensive scheme for licensing and regulating motor vehicles. The following summary sufficiently indicates its provisions. The governor shall appoint a commissioner of motor vehicles with power to designate assistants who shall secure enforcement of the statute before any motor vehicle is operated upon the highways. Notice they said any motor vehicle on the highways is operated upon the highways. The owner shall make a statement to the commissioner and procure a certificate of registration thereafter. It shall bear a numbered plate. This certificate and plate shall be evidence of authority for operating the machine during the current year. They still do the same thing today. Get your license plate, you have to register, and they give you a tag every year. Okay? Registration fees are fixed according to horsepower. $6 when 20 or less, $12 for 20 to 40, and $18 when in excess of 40. And that's pretty much similar to today's standard, you know. It's pretty much the same. It's not that expensive still today to get to register a vehicle and get a tag. No person shall drive a motor vehicle upon the highway until he has obtained a cost of $2 an operator license, subject to revocation for cause. All right, now you see this word person. I'm not that person. That's because you don't know what a person is. A person in law that they use in the public is a device that the public uses in order to identify and classify conduct that people gauge in that is materially affecting the public. Okay, it begins with a definition. They clearly define what the cause of action is. It starts with a definition. Then it goes into whether or not we're talking about an artificial person or a natural person. Artificial person being corporations, natural persons being human beings. It's just a device to classify it in law. All right. Next, they're going to look at the capacity of the individual. Okay. What was the capacity of the natural person? Was it a trustee? Was it an employee? Was it did he act in his individual capacity? Did he act in the capacity of a trustee? Did he act in the capacity of a public official? Did he act in the capacity? Okay. They already have different capacities that are ascribed to the personhood, depending on whether or not it's an artificial person or a natural person. A person don't have nothing to do with some corporation or some sort of invisible man. What they've been telling us for 40 years is a lie. That is the result of individuals who do not study law and who do not understand what things they are reading. The straw man fallacy has been around for a long time, and it has indoctrinated a lot of people. I'm not that person arguments never work, never have worked. And the reason that they don't work is because they're not what you think that they are, okay? It is something, yes, it is in the public. Yes, they capitalize the name to make it a distinction and let you know that it is something involving the public. But it is nothing that you can separate yourself from, because that's like saying that you could separate yourself from your own conduct that you're engaged in. You're claiming that they don't have jurisdiction over you. Okay, my question to you is, if you take a life, okay, are you still saying they don't have jurisdiction over you? Because if they don't have jurisdiction over you, they just don't have jurisdiction over you for nothing. You can't make exceptions to the rule. All right, nobody can touch you. And if in the case of right to travel, are you saying that they don't have jurisdiction over you? Okay, that goes for everybody then. That means that everybody operating a motor vehicle now has the right to operate a motor vehicle without a license, without insurance, without having to obey speed limits, without having to obeying stop signs and traffic laws or whatsoever. And if you violate one of those laws, they pull you over, you can just simply say, I'm not that person and you don't have jurisdiction over me. It's ridiculous and it's stupid. It's ridiculous. It goes on. It says, any owner or operator of an automobile. It says any owner or this is a conjunction. It means in addition to any owner or operator of an automobile, non-resident of Maryland, who has complied with the laws of the state in which he resides, requiring the registration of motor vehicles or licensing of operators thereof, etc., may, under specified conditions, obtain a distinguishing tag and permission to operate such machine over the highways for not exceeding 2 periods of 7 consecutive days in a calendar year without paying the ordinary fees for registration and operator's license. All right, that's the same thing they do today. when you move to a new city, you have your tags from your old state. They give you 30 days to get tags for that city. And that police will pull you over and tell you that. Look how long you've been here. Well, okay, you know, after 30 days, you got to register because you're driving on our roads now. And now you need to register that plate here and pay for the use of these roads. The use of the roads is not free. You don't have an entitlement right to use those roads. That is a convenience. Nobody has to build a road for you. You don't have a right to that. That's not a right. Now, nobody have to nobody had to make a car for you. Nobody had to build a road for you to drive on. All right. Those are no rights. All right. That's at the public expense, and therefore the public can regulate it. Let's keep going. Any owner or operator of an automobile, non-resident of Maryland, who has complied with the laws of the state in which he resides, okay, complied with the laws of the states in which he resides, meaning that I might be just using my car going out of town. All right, like I drive from Texas to Georgia. Okay, I'm gonna have Texas plates on my car. Okay, well, they give you 2 weeks. And back then they gave you 2 weeks. All right, 2 weeks you can drive over here, but after 2 weeks, you're gonna have to register your vehicle here. But we're gonna give you 2 weeks so you can drive. As long as you register it in your state, okay, you can drive here for 2 weeks. Today, they do it the opposite. You register in your state, you got 30 days. After 30 days, you need to go and get a tag to drive in our state. Okay, you need to register the car here. All right, so it says any owner or operator of an automobile, non-resident of Maryland, who has complied with the laws of the state in which he resides, requiring the registration of motor vehicles or licensing of operators thereof, etc., may, under specified conditions, obtain a distinguishing tag and permission to operate such machine over the highways for not exceeding 2 periods of 7 consecutive days in a calendar year without paying the ordinary fees for registration and operator's license. But residents of the District of Columbia are not included amongst those to whom this privilege is granted. Notice that they call this a privilege. Other sections relate to speed, rules of the road, accidents, signals, penalties, arrests, trials, fines, etc. All money collected under the provisions of the Act go to the Commissioner and, except so much as is necessary for salaries and expenses, must be paid into the state treasury to be used in construction, maintaining and repairing the streets of Baltimore and roads built or aided by a county or the state itself. All right, so they tell you what the money is used for that they collect. It's being used for all these fines and fees and tickets and things like that. They go for the repair of the roads and the construction of the roads. Okay, plaintiff in error maintains that the act is void because it discriminates against residents of the District of Columbia, attempts to regulate interstate commerce, violates the rights of citizens of the United States to pass into and through the state, exacts a tax for revenue, not mere compensation for use of facilities. All right, now, right here, notice how they identify that that's what it's all for. It's not mere compensation. What you're paying when you register a car is for compensation for the use of facilities. But what he's arguing is because he's from the District of Columbia, and I would gather this is because the District of Columbia is not a state. It's not a recognized state. Okay, it said attempts to regulate interstate commerce violates the rights of citizens of the United States to pass into and through the state, exacts a tax for revenue. Accordingly to arbitrary classifications, notice we talk about classifications right here. You know, it goes from a definition to personhood, to capacity, to classification, to rights, duties, remedies, and liabilities. It's a formula. They use the same formula all over the world. They use the same formula all over the world, okay? If the statute is otherwise valid, the alleged discrimination against residents of the District of Columbia is not adequate ground for us now to declare it altogether bad. At most, they are entitled to equality of treatment, and in the absence of some definite and authoritative ruling by the courts of the state, we will not assume that, upon a proper showing, this will be denied. The record fails to disclose that Hendrick had complied with the laws in force within the District of Columbia in respect of registering motor vehicles and license operators. Okay, right here, they're saying the record shows, okay, he's sitting here and then filed an appeal, but you still ain't went and got your car registered in the District of Columbia. Okay, you needed to have your car registered. If you want to drive on the roads here, you needed to have your car registered from where you were living at. If you want to pass through here and you didn't have that, so they arrested him. or that he applied to the Maryland commissioner for an identifying tag or marker. When you come to Maryland, okay, you had to get an identifying tag or marker. Now, this is in 1915. So you got to think there wasn't a lot of roads that were created, wasn't a lot of automobiles on the road during this time, and it would be easy to identify cars. Only certain people had cars. You know, it just wasn't a wide variety of people that have cars like they do today. All right. So it says, or that he applied to the Maryland commissioner for an identifying tag or marker. Prerequisites to a limited use of the highways without cost by residents of other states under the plain terms of subsection 148. In other words, it's a prerequisite. All right, you got a prerequisite for you to drive on our Maryland streets. If you have to have your car registered in the state that you're from, and when you pass through here, you got to get an identifying marker or tag to let us know that you paid for it to pass through here. Okay, that is required of residents of the District of Columbia. He cannot therefore set up a claim of discrimination in this particular. Only those whose rights are directly affected can properly question the constitutionality of a state statute and invoke our jurisdiction in respect thereto. All right. He said the movement of motor vehicles over the highways is attended by constant and serious dangers to the public. All right, so right here off the rip, he's talking about public safety. I don't understand why y'all can't read it and see what this is saying. It's very clear. Notice one thing too. I'm not using any AI. Okay, we're not using AI at all. We're just reading it because I don't know why y'all think I'm dependent on AI. I don't need AI. We've been reading case law for over 20 years. Okay, so I'll read this right here. The movement of motor vehicles over the highways is attended by constant and serious dangers to the public, and is also abnormally destructive to the ways themselves. To the ways themselves is the highways, all right? These are ways, highways, all right? In other words, these motor vehicles, they put wear and tear on the streets, okay? And there's also public safety issue because you could kill somebody with one of these automobiles, all right? Their success depends on good roads, the construction and maintenance of which are exceedingly expensive. And in recent years, insistent demands have been made upon the states for better facilities, especially by the ever-increasing number of those who own such vehicles. In other words, the people are all saying we need better roads. I'm doing that here in Dallas right now. Hey, man, we need to fix these roads. And they said, okay, that's fine. You need to register your cars. As is well known, in order to meet the demand and accommodate the growing traffic in the state of Maryland, has built and is maintaining a system of improving roadways, primarily for the enforcement of good order and for the protection of those within its own jurisdiction. The state put into effect the above described general regulations. These are just general regulations, including requirements for registration and licenses. A further evident purpose was to secure some compensation for the use of facilities provided at great cost from the class for whose needs they are essential and whose operations over them are peculiarly injurious. All right, in other words, you're talking about you, the regular people, you know, y'all, we got to get compensation for you because you want these repairs, you want these good roads and everything. All right, it's going to cost us to provide these for you and also to provide safety measures, all right, because this is peculiarly injurious, okay? In the absence of national legislation covering the subject, a state may rightfully prescribe uniform regulations necessary for public safety and order in respect to the operation upon its highways of all motor vehicles. Now, let me say this. I don't know why people are quoting this case right here and saying this is right to travel, because obviously you didn't read the case, and if you did, you have a comprehension problem. Okay, you need to go get some remedial classes. This is not me. This is not anybody tripping or anything like here. It is clear what this is saying, right clear, that they can prescribe regulations necessary for public safety and order in respect to the operation upon its highways of all motor vehicles. Notice how many times they use the word all. There is no exceptions, all right? If you're going to try to carve out an exception, there is no exception. If you're operating a 6-pound piece of metal, it doesn't matter what you call it. It doesn't matter if you call it a conveyance. It don't matter if you're operating privately. You're on a public road operating something that could potentially harm or injure someone else. Therefore, the activity is going to be regulated, and it is a proper subject for the police powers of the state. They're called inherent powers as well, or police powers, and they do not have to be enumerated. Let's look at it real quick. What is police powers? What are police powers definition? In constitutional law, police, now notice this is constitutional. This is under constitutional law. In constitutional law, police power is the inherent authority of a state government to pass laws and create rules. In other words, just by the fact they are the government, it doesn't have to be enumerated. Okay, the government's responsibility is protect your property, protect the borders, and protect your liberty. All right, public safety is the order of the day. That's the first priority of the government. So they're going to do what's necessary. They've been empowered to input regulations. Regulating a right is not taking a right. Just like with handguns, you have a right to bear arms, but they're regulating it. Okay, because that gun can possibly kill someone or injure someone. So we need to regulate it and make sure that it is in the hands of responsible individuals who understand that if it is used irresponsibly, there's going to be some sort of liability attached for that conduct. Okay? So it goes on. All right? In the absence of national legislation covering the subject, in other words, the federal government on the national level hasn't made any laws about this. A state may rightfully prescribe uniform regulations necessary for public safety and order in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce as well as others. So if you had thought for a second, well, this only applies to cars moving in commerce, they're telling you right here it doesn't, okay? It says in addition to that. Now, I don't understand what you're reading. I don't understand who I need to talk to or sit down and have a conversation with. I don't, because I can read. Why would I need to have a conversation with anyone as it relates to this? Because a 7th grader, I can teach an 8th grader this right here. So are you telling me that you don't have an 8th grade comprehension of what you're reading right now? And I know it's going to be some people that are going to get mad and put it in the comment section, but you're just going to look foolish, okay? Because you can get mad and say whatever you want. You can't change what's being read right here. I done read this, I don't know, about 50 times. And it says the same thing every time, every time I read it. And to this end, it may require the registration of such vehicles and the licensing of their drivers, charging therefore reasonable fees, graduated. Hold on for a second. Sorry about that, y'all. All right, let's finish. So right here, in the absence of national legislation covering the subject, in other words, the feds didn't make any national legislation. So in the absence of that, a state may rightfully prescribe. We do know what the word prescribe means, right? We might have to look this word up because a lot of people don't know what the word prescribe means. All right, let's look at the definition of prescribe. To prescribe means to officially tell someone what medical treatment. Oh, wait a minute. Let me go legal definition. Because you can't prescribe medicine. This right here goes to show how you have to look it up. In law, prescribe means that an action, rule, procedure, or penalty is officially set, authorized or required by an authoritative legal source. All right. So this right here, prescribed, mean that they have the power. Okay. They may rightfully prescribe uniform regulations necessary for public safety and in order in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce as well as others. And to this end, it may require the registration of such vehicles and the licensing of their drivers, charging therefore reasonable fees graduated according to the horsepower of the engines, a practical measure of size, speed, and difficulty of control. This is but an exercise of the police power uniformly recognized as belonging to the states and essential to the preservation of the health, safety, and comfort of their citizens, and it does not constitute a direct and material burden on interstate commerce. The reasonableness of the state's action is always subject to inquiry insofar as it affects interstate commerce. In other words, we're always going to look at actions of the state to see if it affects what we got authority over. All right, but in this instance, it doesn't. And in that regard, it is likewise subordinate to the will of Congress. Okay? In Smith versus Alabama, Volume 124, U.S. Reporter, page 465, and Volume 124, U.S. Reporter, page 480, consideration was given to the validity of an Alabama statute forbidding any engineer to operate a railroad train without first undergoing an examination, touching its fitness, and obtaining a license for which a fee was charged. The language of the court, speaking through Mr. Justice Matthews, in reply to the suggestion that the statute unduly burdened interstate commerce and was therefore void, aptly declares the doctrine which is applicable here, he said. Okay, in other words, he's giving an example now of a situation where they were requiring certain things and it did possibly materially affect interstate commerce. It says, but the provisions of the subject contained in the statute of Alabama under consideration are not regulations of interstate commerce. It is a misnomer to call them such. Considered in themselves, they are part of that body of the local law, which, as we've already seen, properly governs the relation between carriers of passengers and merchandise and the public who employ them, which are not displaced until they come into conflict with expressed enactments of Congress in the exercise of its power over commerce, and which, until so displaced, according to the evident intention of Congress, remain as the law governing carriers in the discharge of their obligations. This right here is showing me where people really don't understand how to read case law. In this section right here, they're talking about an alternative to this. We're talking about railroads and something that could possibly affect interstate commerce. Remember that Congress has the authority under Article 1, Section 8, Clause 3 to regulate commerce or anything materially affecting interstate commerce. So the first thing they looked to see if this was constitutional or unconstitutional on the federal level was to see, does this violate interstate commerce? And they said that it doesn't. They're giving you another example of something that does. So, all right, so the prescribed regulation upon its face do not appear to be either unnecessary or unreasonable. In view of the many decisions of the court, there can be no serious doubt that where a state at its own expense furnishes special facilities for the use of those engaged in commerce, interstate as well as domestic, it may exact compensation therefor. The amount of the charges and the method of collection are primarily for determination by the state itself. And so long as they are reasonable and are fixed according to some uniform, fair, and practical standard, they constitute no burden on interstate commerce. So right here, what people are doing who do a cursory view of this case, they look in through this and see this word commerce, and automatically they start assuming, well, I'm not moving in commerce, so this don't apply to me. That's not what this is saying. They're just using an illustration of something that touches interstate commerce. But in the beginning of this, they say, look, state laws that regulate motor vehicles do not affect interstate commerce. Therefore, it is not within the purview of the federal government to make any determination on it. Hello? Yes. Sorry about that. Okay. So, all right, so where were we? Okay, so in other words, as I was saying, when you read this case, you have to understand what you're reading. What people will do is they will skim over it, see instances in there where it's talking about interstate commerce, and then start to interpret that, oh, this only relates to cars operating in commerce. That is not what this is saying at all. You know, it starts off telling you very clearly. He's just giving you other examples in other case law about something that could materially affect interstate commerce, and it still wasn't unreasonable. It still wasn't unreasonable. It says, in view of the many decisions of this court, notice this, that they consistent. There can be no serious doubt that where a state at its own expense furnishes special facilities for the use of those engaged in commerce, interstate as well as domestic, it may exact compensation therefor. The amount of the charges and the method of collection are primarily for determination by the state itself. And so long as they are reasonable and are fixed according to some uniform, fair, and practical standard, they constitute no burden on interstate commerce. All right? This case was a case about interstate commerce. That doesn't mean that the right to travel or operate these motor vehicles only solely deals with interstate commerce. They just give you an example of this because he started off by telling you, like, look, this don't affect, this case ain't about interstate commerce. They tell you that in the beginning. It goes on, it says, the action of the state must be treated as correct unless the contrary is made to appear. In the instant case, there is no evidence concerning the value of the facilities supplied by the state, the cost of maintaining them, or the fairness of the methods adopted for collecting the charges imposed. And we cannot say from a mere inspection of the statute that its provisions are arbitrary or unreasonable. There is no solid foundation for the claim that the statute directly interferes with the rights of citizens of the United States to pass through the state and is consequently bad according to the doctrine announced in Crandall versus Nevada. In that case, a direct tax was laid upon the passenger for the privilege of leaving the state, while here, the statute at most attempts to regulate the operations of dangerous machines on the highways and to charge for the use of valuable facilities. In other words, we're charging for the use of the road, and also we got to license you to make sure that you're competent enough to drive on public highways. All right. This other case that they're talking about was talking about somebody leaving. That was somebody trying to go to another state to get a job. Didn't have anything to do with the automobile or anything like that. But y'all try to say right to travel just means the right to go state to state. Don't have anything about the mode of travel. And let me try to explain it to you one more time. The people in the United States of America, they were white people that came from England. Okay, they brought their laws and their customs with them. All right, most of the laws in the United States of America come from William Blackstone commentaries and the Bible. All right, the Christian Bible. Okay, and when you go over into Europe, it's set up just like it is in the United States. You can look at Germany, the Netherlands, Belgium, Switzerland, France, Spain, Portugal, Italy, Greece, all these different countries over there as states like you have over here in the United States. We got the same thing. You know, when I go over to Europe, I visit about 8 different countries. Okay, because it ain't no different than going from Georgia to Florida, from Florida to Louisiana, and Louisiana to Texas, and then Texas to Alabama. Okay, only here in the United States, we can move like that, and they don't require a passport. There are no borders at the state lines requiring us to show identification before we can pass into that country. Over in there, it's not like that. All right, so they gave you the right to travel in the United States, and that's why we're called the United States of America, because we're united. That's what right to travel means. It doesn't mean anything what y'all are talking about with these automobiles. Let's keep reading. Notice we're talking about capacity. All right, as the capacity of the machine owned by plaintiff in error does not appear, okay, we don't see what the capacity of it is. He cannot complain of discrimination because fees are imposed according to engine power. All right, we didn't see nobody, he didn't make known, well, what is the capacity of your car? 6-cylinder, 4-cylinder, 8-cylinder, you know, is it a truck, diesel, what is it? That didn't appear. Distinctions amongst motor vehicles and between them and other vehicles may be proper, essential indeed, and those now challenged are not obviously arbitrary or oppressive. The statute is not a mere revenue measure, and a discussion of the classifications permissible under such an act would not be pertinent. Notice that they are making references to capacity and classification. Earlier, that's what I said. It goes from definitions to the word person, whether artificial or natural, to capacity, to determine the capacity of the person in question, and then the classification of the conduct, and in order to determine rights, duties, liabilities, and remedies. Okay? This is the formula. Everything in the public operates through some sort of formula or procedure. Everything in the public. Everything in the public. Everything in the public is structured. The private is not structured. And they do that, they have to structure it because that's what ensures they stay within the ambit of delegated authority. So when you get pulled over by a police officer and you say, how are you a police officer? You don't know the Constitution. He doesn't have to know the Constitution. First of all, if he's a sheriff deputy, he gets a delegation of authority from the sheriff. So now he's been deputized, and the sheriff is giving him procedures to follow. If he follows those procedures, he stays within his constitutional authority. That's why the procedures are there. If he follows them to the letter, he has nothing to worry about, okay? That's why they do. That's with everything in the public. And that's why when a police officer does something, like if somebody gets injured or something by a police officer and they put them on 2 weeks leave, and you see them come back and they step to the podium and say, well, we didn't see anything he did wrong. He followed procedure. And then y'all want to start picketing and protesting. Well, that's what their defense is. They don't have to. And all of the procedures are reviewed by the Supreme Court. Justices to ensure they're constitutional. How do I know? Because you can get the United States Code annotated and it's right there in the introduction if you ever read it. All right, there is no error in the judgment complained of and is accordingly affirmed. All right, any owner or operator, not a resident of this state, who shall have complied with the laws of the state in which he resides, requiring the registration of motor vehicles or licensing of operators thereof, and the display of identification or registration numbers on such vehicle, and who shall cause the identification numbers of such state in accordance with the laws thereof, and none other, together with the initial letter of said state, to be displayed on his motor vehicle, and in this subtle subtitle provided, while used or operated upon the public highways of this state, may use such highways not exceeding 2 periods of 7 consecutive. They give me the state statute back then in 1915. All right, that's what that is, but they affirmed it. This wasn't a long decision. I am lost how anybody can read this. No AI, no need to use AI. Okay, obviously you need AI because you cannot read this and comprehend what it's saying because you don't know how to read case law. You don't know how to separate things that they're talking about. There's certain things, a couple of things. They're making reference to interstate commerce. They're making reference to state regulations and the police powers of the state, how it applies to anything. They tell you the reason why you get a license and the reason why you have to register your car. Okay, I haven't seen anything in any of these cases that people have brought to me. All of them say this exact same thing. Exact same thing. I'm gonna just put it out there. If you're saying that this right here case is talking about that it gives you the right to travel, you're illiterate. You're illiterate. You can get mad at me all you want to. I'm just telling you the truth. You know, I'm just telling the truth. See, like, look at this dude right here. SBC needs to go read session laws. I don't need to read session laws. I'm reading a Supreme Court decision. This is a Supreme Court decision. Look at this. Look at this guy. This Danny 74-638. This is what y'all have to deal with in the echo chambers. He said that I need to go read session laws. No, I'm reading the Supreme Court. This is a Supreme Court decision, bro. You don't see Supreme Court right there? I don't understand. I mean, I see what the attorneys are saying about y'all. Y'all are lunatics. You're lunatics. And this is coming from someone who's been in this space for 20 years. I'm sitting there telling you this. Right to travel is bullshit, okay? It don't have anything. I've studied this. I've looked at everything that y'all have said. We can, if not, we can go. This is where they get their stuff from, y'all. This is where they get it from right here. I got this when I first got into this 20 years ago. I was given this document. It's called Abatement at Common Law. Let me just look at my Dropbox for it. So I've been knowing about right to travel for 20 years, but I never, what my thing, because I'm doing secure party. This ain't my thing, So they'll say, oh, the word drive is a commercial term. It is a commercial term. It did reference a drive like bus driver, taxi driver, all these different things. But in this instance, the regulations don't apply to that. Don't have nothing to do with commerce. This is what these people can't seem to understand. They can't understand. I don't need to do anything. You need to go read the session laws, and you need to see them for yourself. Because I guarantee you they don't say what you think they're saying. Like, as I said, you have a problem with comprehension. You just are. You have a problem with comprehension. There was nothing in that case y'all quote this case. Y'all quote this case consistently. There's nothing in this case that supports what you're saying. Nothing. Run it through ChatGPT. I didn't use I'm not using any AI right now. All right, because y'all like to say that shit. I'm reading the case. Nothing in there talking about this shit. All right, let's go. This right here is where they get it. Don Quixote School of Law. All right, now let's look at what he said. Now, this dude claims to be a Juris Doctorate. All right, Don Quixote JD. I don't know if he is or not. But let's look at his approach. He's using an abatement tactic, which is sometimes referred to as a dilatory tactic, because it's going to the procedural elements of what it is that is attacking it through procedure. So it says, there are many that believe that special appearances by paperwork, motions, etc., nullify a court's jurisdiction. Under emergency powers, this is false doctrine. There is no remedy in challenging the court's jurisdiction except by abating its process first. Now, this is what this man, this is the right to travel Bible right here. A lot of them don't know this is the Bible. They don't know where they're getting all the stuff that they're talking about. That's why I'm giving it to you right now, because they don't know where they're getting all this stuff. But this is the right to travel Bible. There's not a single right to travel document on the internet that you can't find that doesn't tie back into this document right here, that somebody can pull something out of it and using it from this document right here. It says, there is no remedy in challenging the court's jurisdiction except by abating its process first. Abatements are not a challenge to a court's jurisdiction, merely a good faith attempt to correct errors in process. Clear up the errors, judge, and all appear. Special appearances fail when the judge knows what he's doing. Under martial rule, judges do whatever they want, whenever they want, so long as he or she does not alarm the public or disturb the peace. Jurisdiction is always granted to try jurisdictional questions, even if one goes to higher courts. Defendants grant jurisdiction without knowing it because they never challenge the process that creates the jurisdiction in the first place. Federal Rule of Civil Procedure, subsection 2.424. Process is perfected by appearance, special or otherwise. Also remember, the court is, that's why when you come into court, you say you didn't get service of process. They say, well, you're here. You're here. Process is perfected by appearance, special or otherwise. Also remember, the court is not the building, the judge, or anyone else. It is the paperwork. If the court paperwork is defective, there is no court and it ceases to exist. The only way to overcome the war powers court process is by abatement. Traffic tickets are a pain for all of us. When using this abatement strategy, first send in the notice of abatement, memorandum of law, and denial of corporate existence. This is his administrative process, in case you're wondering. Okay, he has an administrative process you conduct. But let's see if this administrative process that he's talking about has any foundation. All right, so first send in the notice of abatement, memorandum of law, and denial of corporate existence to the clerk of court. That generally takes care of the annoying ticket. If you do not hear from him within 15 days, send in a default notice of the notary to the clerk, all right, which is the administrative process. If you receive a summons which has the proper signature of the judge and the court seal, send in a subpoena and discovery interrogatories to the prosecuting attorney and the court. You're challenging jurisdiction, and the opposing party must traverse your challenge, or the court cannot proceed. In most cases, they will never give you the documents you have requested or answer your questions. If they do, you won. The people granted authority to the state legislatures to adjudicate only a few matters: actions at law, actions in equity, and actions under the rule of necessity, military. Admiralty was remanded to the federal government, and the states are supposed to have no authority to legislate in that jurisdiction. Agreed. But it's not an admiralty jurisdiction. It's not called that. There was a time when someone aggrieved of harm would file a tort at law. Moreover, the nature of the action governed the rules of the procedure. If there was a breach of contract, then this was an equity matter. If the aggrieved party could allege a tortious breach of contract, this matter was moved from the equity side of the court into the law side of the court. This is because the people must have access to a remedy at law if this type of action could give relief. If one were in the military, or if one were under territory and martial law, the court was a military court. If there was a breach of an international contract, the matter was federal and heard under admiralty. The state legislature cannot vest a court with authority that has not been delegated to it by the people via the constitution of the state. Now, I'm sorry, okay? The police powers of the state don't have to be enumerated. This falls under the police powers of the state. So right here I have to question, this guy is claiming to be a JD, and he doesn't know that. They cannot create a new nature of action out of thin air. I agree with that. This is why everybody was going in and asking if it's civil or criminal, and so forth. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, a separate court was established, and the action was in the nature of these administrative courts. All right? Live people could not be brought into an administrative court, as the only matter at issue was a breach of corporate charter by an artificial person. Somewhere along the line, the announcement in the complaint of the nature of the action was lost. The attorneys all got together and decided that it would be much simpler for them if there was only one form of action. Okay, where did they get that? You know, this right here, when it starts falling into this conspiracy theory shit, because I ain't been able to confirm that, unless they're talking about it's only one form of action, and the civil action in the federal rules of civil procedure, I think is 2 of the federal rules of civil procedure. I think I said, is it 2? There shall be one action, a civil action. I think that's what United States Code. What is it? Yeah, Rule 2. All right, the statement comes from Rule 2 of the Federal Rules of Civil Procedure found in U.S. Court. It means that the law uses only one type of case for legal rights and claims, combining old separate rules for law and equity. What Rule 2 means: one type. There's no split between law cases and equity cases. Same steps. Every claim uses the same basic steps of court rules. Easy start. You file a simple complaint to begin. Why it matters? No confusion. You know, they merge law and equity. All right. So let's get back right here. All right, so it says the attorneys all got together and decided it would be much simpler for them if there were only one form of action. So today there is no disclosure of the nature of the action unless one demands to know the nature of the cause of the accusation by using the demand for a bill of particulars. There were guys out there, you see all of them come up with a new remedy trying to sell everybody, talking about a bill of particulars. I have been quite successful with this procedure, even in states that have decided that a demand for a bill of particulars is a discretionary motion before the court. For example, in Pennsylvania, the demand for a bill of particulars used to be before arraignment so that one had an opportunity to raise a meaningful defense against the elements of personal jurisdiction and venue, to include territorial jurisdiction, as well as the nature of the action that used to be a part of subject matter jurisdiction. Within the past couple of decades, they moved it into discovery, which is after arraignment, so the ability of one to challenge the jurisdiction and venue of the court was lost. This is because entering a plea accepts the jurisdiction. In this way, only subject matter jurisdiction was challengeable. If they say this is a matter at law, my defense against this jurisdiction is whether there is a live damaged party. I do not ask if this is an equity jurisdiction, because equity is not a criminal type of action. Remember what I said when you asked is it civil or criminal? And when they say criminal, that eliminates equity. If they say this is a matter in hustings, which is the true nature of action of all administrative law, is a matter of hustings is like a deliberative assembly. Matter in hustings. Is matter in hustings. I believe it's a deliberative assembly. The phrase matter in hustings does not represent a standard unified single legal term. Instead, it combines the general legal word matter, an issue, case, or dispute, with hustings, which historically referred to a local judicial and municipal assembly, such as a court of hustings in London, and modernly refers to an election campaign platform or debate. All right, okay, there it goes. You can look it up in a Black's Law Dictionary. You should look up the word, know what it means. All right. So if they say this is a matter in hustings, which is the true nature of action of all administrative law, my defense against this jurisdiction is that I'm not an artificial person unless I'm a federal citizen, but that is quite another matter entirely. Okay, well, you're not an artificial person in the sense you're not a corporation, but you are a natural person. But let's keep going, unless they can show from the record in the Secretary of State's office that I've chartered as such. If they say this is an admiralty matter, my defense against this jurisdiction is whether the offense was committed on federal territory, over which the state has retained concurrent jurisdiction, although I have not found how the state exercises an admiralty jurisdiction in light of 28 United States Code subsection 1333. I agree with that. If they say this is a military matter, my defense against this jurisdiction is that, one, I am not a member of their military. I am, however, a member of the militia of one of the several states, but they do not operate as such anymore. And two, the nation is not under martial law, or is it? Given the fact that there are currently 14 notices from the president of a declaration of national emergency established in the Federal Register, we may very well be in a state of martial law. I agree with that. The one from March 6, AD 1933 is still in effect today. Agreed. However, they are not going to admit the nature of the action, as this will admit their want of jurisdiction on the record for all to see. I agree with that, because I'm going into court, they don't. So they move to dismiss the charges every time. While I will never succeed in bringing down the current regime in this manner, at least other folks see what I'm doing, and some decide along the way they want to learn the procedure. I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, that we could most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. As far as the compelling government interest doctrine, this is a clearly matter founded in law, martial rule. I don't agree with that. What do you mean clearly founded in law, martial rule? I don't agree with that at all. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. Where'd you get that information from? You know, this is when you start looking at what he's saying, because he got a lot of instances like in here that maybe he knows some stuff, but it seems like he's confused on some things too. It says, now I love this right here, what he said. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I am therefore unable to enter a plea to the charge until I've had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. I like that. That's beautiful. If you're going to challenge jurisdiction and you're in arraignment or something, I think this is something you could appropriately say in a court. The courts operate on silent judicial notice of presumption all the time. It is time for this to end. Generally, when you appear, the police officer is not there because he's been instructed to stay at home that day. You simply move for dismissal for lack of prosecution, as the prosecutor cannot testify to facts which he has no first-hand knowledge of. Be especially careful of the judge's conduct. He is required by his oath of office to be an impartial trier of fact, not the assistant prosecutor. Have fun, but do not abuse the procedure, or it may become ineffective because of abuse. All of it already has. All right. So he got this thing, this script that they claim they used. This wasn't in the original. Somebody added this in here. All right. But we get down here. It got this, it's abatement. First petition abatement comes down John Allen Doe after petitioner to petition the court to abate the above referenced accusation complaint on the following grounds. Petitioner is respectfully requires that you abate the above reference Texas Uniform Traffic Citation and Complaint. Petitioner is a natural man living upon the soil of the state of Texas. Petitioner is not exercising, let's say petitioner is a real living soul. He put natural man here. They're going to convert it to natural person. Living upon the soil of the Republic of Texas. Petitioner is not exercising petitioner's right to travel freely within the state to engage in commercial activity. All right, so he thinks also that this is I'm showing y'all where this came from. this misunderstanding of it. All right, how they attribute it to commercial activity. As petitioner's travel is not a commercial activity. Petitioner is not subject to being detained or summoned to this court by officer, trooper, name and number officer exercising the police power of the state to enforce its private commercial statutes in commerce. That's not what this is. It's an exercise of police power. Below are some of the petitioner's reasons, as we just read in Hendrick versus Maryland. Below are some of the petitioner's reasons as to why petitioner will not appear unless defects in the service of process are corrected. Notice of abatement for improper service. Petitioner was presented with a paper styled in capital letters as, all caps name. Petitioner has received but has not accepted the uniform traffic citation and complaint and is hereby rejecting said document for cause without dishonor. Petitioner is returning said document marked without prejudice, thereby retaining all of his or her rights in law and equity as petitioner challenges the subject matter and in personam jurisdiction of the court for the following causes. Courts enforcing mere statutes do not act judicially, merely ministerial, having thus no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Now, a lot of people have quoted this ad nauseum. This right here, Boswell versus Otis. All right, Boswell. We're gonna come back to this. We're gonna pull this one up and look at it and see if this is what it actually says. Service of a traffic ticket on a motorist does not give the court jurisdiction over his person. Service of a traffic ticket imposes no compulsion on him, and no penalty attached for failure to heed it. Purpose of traffic ticket is to secure the motorist's voluntary appearance. Actually, equity acts in personam. Equity, and they've merged law and equity. So I'm not sure about what he's saying right here. If the Texas State Uniform Traffic Citation and Complaint is a summons requiring petitioner's appearance, the following defects must be corrected before I will submit to the court's jurisdiction. The mandate contained within the 5th article of amendment of the Constitution of the United States requires as due process, namely, meaning initiatives through judicial courts with proper jurisdiction, precedes the imposition of administratively issued summonses. Let me try to condense this down because I know a lot of people, they always talk about I'm real complex. Basically, what his contention is going to be that you're subjecting me to legislative process and not judicial process. In other words, I should be subject to like an Article 3 style court and not a legislative or an administrative court. However, I argue that operating motor vehicles does fall under the purview of the administrative state because the statutes and everything are how the government exercises their constitutionally delegated powers. Right? And that only applies within the public. It has no application in the private. So they can use administrative courts to adjudicate that. Now, I do have some question on their ability to lock people up. That is something I'm exploring. All right. But as far as hitting you with a fine or a penalty or something like that, yes. That's why the people came up with secure party, because they saw early on that the only hole in everything that they were doing is that they were using fictitious money. They were using Federal Reserve notes. That's why the secure party process was the first process. Out of all this shit y'all doing, the first one to come out was the secure party process. All this plethora of other shit you're doing came after that because that's what they saw. They saw, well, yeah, they got jurisdiction, but ain't no real money. How you going to require us to pay something in Federal Reserve notes when you can't require us to pay in any particular species of currency? And that's where the argument laid, and y'all got away from that. That's why, years ago, everybody was doing acceptance for value and all of that. That was the remedy everybody was doing. Not all this, you don't have jurisdiction over me stuff. All right. So let me just skip past this. He's just talking about the, now let's look at this. Let's look at this real quick. Now I want to read this. It says, the prohibition of personal service of process by parties is to discourage fraudulent service by persons with an adversarial interest in a legal action. It appears from the return document that your organization is requesting my voluntary appearance, but threatening me with conviction and judgment for an undisclosed amount exceeding the basic fine if I do not voluntarily comply. In light of the case law cited above, and that by voluntarily subjecting myself to your organization's jurisdiction, I will put my personal property at a substantial risk of loss. Your organization's coercive threats of retaliation for the exercise of stewardship over my personal property seem inappropriate and unconstitutional. I don't know why it got seen. in denying me due process of law, especially inappropriate in light of the fact that I'm advised by a decision of the Supreme Court, United States Supreme Court, to pause, reflect, and accurately ascertain your organization's official capacity and authority. It is well established by the Supreme Court of the United States that whatever the form in which the government functions, anyone entering into an arrangement with the government takes the risk of having accurately ascertained that he who purports to act for the government stays within the bound of his authority. Now, this is a very good quote, and it is worth studying. All right, that anybody that you come into in the public government actor, if you don't question his delegation of authority, then it's going to be presumed that he acted within the purview of it. I remember this case, and this is a good case to write down. I've included within this communication a memorandum of law on the subject of petitioner's unalienable right to travel upon the public highway. Petitioner thinks that this will enlighten this court as to petitioner's lawful position and will give this court ample evidence and reason to abate the traffic citation. Petitioner expects your response to petitioner's abatement and correction of the errors by the issuance of a proper summons or an affidavit in rebuttal to the above lawful position, signed by the appropriate judicial officer in blue ink with the court seal of your organization and service of the summons by the county sheriff. In addition, a clarification of any error you claim petitioner has made in this abatement, along with all the documents you offer in support of your position within the reasonable time period of 15 days of your receipt of this notice of abatement. If you need additional time, please make your request in writing and it will be granted. The petitioner does not hear from you within 15, and this is all his administrative process stuff. I'm not going to waste time reading this. All right, he's giving them 15 days to respond, and he wants them to conduct what he believes is a proper service of process upon him if they want him to appear in court. He's saying that a traffic citation is not a proper way to summon somebody into court, all right, and it's affecting due process, and that's why he's using this abatement style procedure to accomplish this. All right, so right here, he got an affidavit of denial of corporate existence. Now, I will say this, that in Louisiana, there was something interesting that I found in Louisiana. It's in the state statute. Yes, Title 15, subsection 29, right here. It says, on a trial of any criminal case, it shall not be necessary to prove the incorporation of any corporation mentioned in the indictment unless the defendant, before entering upon such trial, shall have filed his affidavit specifically denying the existence of such corporation. I found that interesting. I found that to be every now. I would have to put this in its proper context. Okay, what is Title 15 in Louisiana? Is this the criminal code? And what is this relating to? Because just reading it on its face of the statute is not going to tell you the entire story. I would actually need to go to the law library and see how the judges applied this statute and with facts that have appeared before the court to get an understanding of its proper application. This is a statute, but I will admit that this was a very interesting statute that I found. Most of you probably don't even know this exists. All right, but it goes on. All right, so 1, use avail the living man and state birth, hereinafter exempt, hereinafter affiant, declares and states that the following facts are true to the best of my knowledge and belief, and of which one has firsthand knowledge of the matter stated herein. 1, use avail is of the age of majority and competent to testify on the matter stated herein. If any man or woman desires to answer this affidavit, please do so in the manner of this instrument. By notarized affidavit using your Christian or family name for signature and mail to the below named notary, address provided within 5 days or default will be obtained. Your handwritten signature only, do not type it out. And he goes into this long thing, but now this is really interesting. You should read this. Affiant hereby denies that the following corporations exist and their capacity to sue or be sued is challenged by negative affirmation. So he's doing a negative affirmation, claiming he's making them prove that these exist. All other corporate members who are or may be associated with any complaints against my natural body. 1, Yusef has no contract with the state or federal government, which gives equity jurisdiction to the courts. 1 has no bank account and no credit cards. Notice he on no bank account or credit cards. Okay, he's identifying the minimum contacts that would give them that. 1 has rescinded the government social security number and any present or future benefits of that socialist system for religious conviction. Whether you can rescind the social security number or not, I don't think so. However, you got SSA form 521 that a lot of people use. Request for withdrawal of application. Do you want to do that? Okay. All right, goes on. One has rescinded. Okay, one, Yusef has signed no international maritime agreement with the state or federal governments, either intentionally, willingly, or knowingly, which would give admiralty or vice admiralty jurisdiction to the courts of either state or federal governments, and does not voluntarily submit to any of those jurisdictions. One, Yusef is subject only to the common law of the Republic State of, and I'm questioning whether he understands what common law is. Doesn't appear so. One, Yusef is subject to the common law of the Republic State of and United States of America and is not subject to any corporation or system of administrative law. One, Yusef is not a corporation or a member of a corporation, a trustee or beneficiary of any trust created by government, is not a legal fiction or juristic personality, and refutes any unknown nexus which might attach to him to any such entity or jurisdiction. One, Yusef cannot be held in involuntary servitude or peonage pursuant to the 13th Amendment of the United States Constitution. One, cannot be held as surety or collateral for any bankruptcy of the corporate, federal, or state government without my permission, which has never been given. One, Yusef has never applied for bankruptcy, has never given his permission to the state or federal governments for his participation in any bankruptcy scheme of the federal or state government or the Federal Reserve Bank. Yeah, you did when you got a social security number. One, Yusef is a live, natural man living upon the soil of the sovereign Republic of Texas. One, Yusef is not subject to the federal law legislated by Congress under its authority of Article 4 of the Constitution for the United States or any state or federal admiralty/equity judicial jurisdiction. One, Yusef is subject only to the law legislated by Congress under its authority of Article 1 of the Constitution for the United States if the law has complied with the Paperwork Reduction Act, the Administrative Procedures Act, and the Federal Register Act, which would specifically identify the law as being applicable to the general population of the 50 Union States of America. One, Yusef, well, nobody's claiming this federally. One, Yusef is subject only to a Republican form of government pursuant to the national Constitution and the Constitution of your state under the equal footing doctrine of the Constitution for the United States of America, not under a corporate municipal form of a quasi-military form of government known as either democracy or martial rule. Further find says not. Okay, so we get a gist of what he's trying to say. So let's look at this right here. And he's doing an administrative process. Here's a notice in demand for abatement right here. That's another copy of it. This is what is interesting right here. This letter that he writes to the judge. This right here, to me, is the best document in this entire thing because it highlights exactly, he tries to give a distinction between a legislative jurisdiction and a judicial jurisdiction, and I think he does a very good job of it. Let's look and see. It says, when I specially visit your court on a forced response on such and such date to a bill of pains and penalties. What is a bill of pains and penalties? When you're being subjected to an administrative court, not a judicial court. All right? Bill of pains and penalties. Bill of pains and penalties. A bill of pains and penalties is a historical law passed by a legislature that punishes a named person or a group without a regular court trial. It declares the target guilty and gives a punishment less severe than death, such as taking away property, banishment, or losing the right to vote. Okay? All right, so bill of particulars definition. Pain and penalties. A past practice of issuing a legislative act designed to inflict a penalty not amounting to capital punishment, bypassing a formal court trial. And what is he saying by this? He's saying that I'm supposed to be subjected to judicial process, not legislative process, something that I've been arguing about the distinction between these Article 1 and Article 3 courts and exactly what are the U.S. district courts or these administrative courts. What is the true nature of these courts? That's what I've been actually researching. Okay, it says, when I specially visit your court on a forced response on such and such date to a bill of pains and penalties issued by the such and such officer, employed by the police agency, employed by the corporate such and such state. I move this court and you, judge, to take judicial notice that my special visitation was forced, that my visitation is special and not general, since this notice is my timely and specific objection to the presumptions upon which a false conclusion of law has been made administratively with regard to my status before the court. The plaintiff in this case is an administrative officer representing the corporate and de facto state of Texas, which has legislative power to compel performance upon the letter of its statutes upon all persons subject to its jurisdiction. The only due process that its legislative courts recognize is the right to be heard on the facts of a case. Yeah, because administrative courts are by compliance. They're by compliance. The corporate plaintiff in this criminal action before this court has made an unproven conclusion of law that Yusef is among those persons who have lost or otherwise abandoned their status in the guaranteed Republican form of government and who must perform under legislative power upon the exact letter of every legislative statute with no due process of law protection other than that outlined in paragraph 2 of this letter. It is from this false conclusion of law that administrative officer such and such officer issued the contested bill of pains and penalties upon Yusef. This court must take judicial notice that Yusef is an unenfranchised individual, has made a contrary conclusion of law to that of plaintiff. Yusef claims his guaranteed fundamental and unalienable rights stemming from both the national and state constitutions to full due process of law and all criminal actions against him means he is subject only to judicial power, not legislative power. All right, see right there, he's only subject to judicial power, not legislative power. He's calling the court an Article 1 court. He's attacking the nature of the court that's actually summoning him. He's saying he's supposed to be saying I'm a private individual, therefore, but he don't understand that that status don't have anything to do with a declaration. It has to do with your conduct. This is where everybody is confused. They think that they can declare a certain status and now they are exempt from certain process just by the declaration made without any corresponding change in their conduct or any structure that's been put in place. That's not how you do this. And this is where he's confused on this. But he's right about questioning what kind of court it is. He's right about that. He said judicial power when exercised over him requires a corpus delicti or a damaged party who has sworn out a verified complaint against him. This is lacking in the criminal complaint against Yusef brought on by the plaintiff. So the unlawfully charged Yusef declares that this unenfranchised status as a preamble American citizen of the guaranteed Republican form of government known as the United States of America, an inhabitant of the state of Texas. Notice he called himself an inhabitant, not a domicile, not a resident, okay, of the state, that without a corpus delicti, no court, judicial, or legislative tribunal has a criminal jurisdiction over his person or property. Therefore, the accused specially visits before the law side of this court, seeking its protection from the excess zeal of corporate government, trusting that this court will assume a neutral stance at law and require the corporate plaintiff in this criminal action to prove its in rem and or in personam criminal jurisdiction over the accused to be a fact of law before this court would take on the role of judging the facts of this legislative charge brought before you. Your solemn oath of office compels nothing less from you. I like how this was worded. However, there seems to be some errors in it. Presumptively, he's thinking, well, you can engage in see, this is what he's thinking, that you can engage in the activity of operating a 6,000-pound piece of metal on public roads without any type of regulation. And he's subject only to judicial process and not administrative process. That is not true. That's not true. All right, that's not true. Once again, this is these new remedies. But anyway, let me, and he's requesting a subpoena. Now, he's going to inundate them with paperwork and request certain things from them. And I can see how this could possibly get something dismissed, especially if the business of the court, they don't have time to deal with all this. He's issuing a subpoena ducis tecum. That's a subpoena for documents that he's requiring, which is definitely an effective tool to utilize. You should learn about subpoena ducis tecum. For named officer as a witness and to produce the following legal papers, documents, records under his control for the trial date, as these documents are absolutely essential for the accused defense. And, and he got all these things that he's requiring of them. And down here, he has this is another notice in demand for abatement again. It's another repeat. But it's right here, you have a petitioner's memorandum of law in support of notice to abate. Okay, and this is where they pull out a lot of this case law that is incorrect. You will see it. Rights, personal liberty, or the rights to enjoyment of life and property is one of the fundamental and natural rights which has been protected by its inclusion as a guaranteed in the various constitutions, which is not derived from or dependent on the U.S. Constitution. Well, okay, that's fine. That nobody's questioning that. You do. personal liberty, right of locomotion to go where and when one pleases, only so far as the rights of others may make it necessary for the welfare of all other citizens, the right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which has under its right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's right, he will be protected not only in his person, but in his safe conduct. True, but it doesn't mean that you cannot be regulated. This is what the case is going to say, and we're gonna pull this case because is this Tompkins versus? Oh, this is American jurisprudence. But it gets into it and says they can regulate it. We're going to look at this. All right. They can regulate it. That doesn't mean you can't. They're saying we're not infringing on your right to travel from state to state. All right. What we're doing is we're regulating the activity because it's a public safety question. Okay. You can travel with a bicycle. You can travel in a bus. You can travel on a skateboard. You can travel on a plane. All right. However, when you start engaging in activity or conduct that is a potential threat to the safety and welfare of other citizens, we're going to regulate the activity. Okay. And that's what the government does. And that is within their constitutional delegation of authority to do. I don't see anything and what you're talking about. It's the Justice Tolman quote in here. This right here. This is the distinction. This right here is public and private. This is public down here. This is private up here. I do this in all my seminars, use that Hale versus Hinkle. Based on the fundamental ground that the sovereign state has the plenary control of the street and highways and the exercise of this police power, they absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. Okay, in this particular, yes, this case was about that. That doesn't mean that it only is for business and gain, like we just read by the Supreme Court decision. They made it clear. It ain't just dealing with commerce. Any car that's on the road, okay? But this particular case was talking about a matter of commerce. This is exhausting. You do have a right of vehicular travel on the roads. You don't have, but it doesn't say you have a right to travel in a car. But it don't say it can't be regulated. Rights can be regulated. Rights can be regulated. Can rights be regulated? Can rights be regulated? Can rights be regulated? Yes, rights can be regulated. Almost no right is absolute. Governments routinely pass laws and rules to balance individual freedoms with public safety, order, and the right of others. What is it you don't understand? I'll tell you why. Because a lot of you are illiterate. Listen, man, most of the country reads on a 7th grade level. I'm not saying that to insult any of you. You're going to have to acknowledge that fact, okay? You're attempting to sit here and read something, right? It's clear as day. What is right to travel? Right to travel, everywhere you look up the definition of right to travel, it gives you the definition. The constitutional right to travel is a fundamental, unenumerated liberty that allows U.S. citizens to move freely between states. Unreasonable government interference. Unreasonable. Doesn't say they can't interfere. It says it has to be unreasonable. And that's why in that Hendrick versus Maryland, the judge kept saying this is not unreasonable. He kept making that reference. This is not unreasonable. Rights can be regulated. We're talking about regulations. Y'all are retarded. I'm just telling you. You get mad at me all you want. You're not going to change any of the words in any of these cases under these laws. You're not going to change it. You have a right to travel. You don't have a right to travel unregulated. That's the distinction. That don't have nothing to do with compensation. Let me go back and read Hendrick versus Maryland, because they obviously were gone. Let's read Hendrick versus Maryland again, because this is a Supreme Court case. And this is one they like to quote too. Hendrick versus, they in the chat right now talking about, oh yeah, that's when you operated a business. Let's see if that's true. Only those whose rights are directly affected. Let's get down here. Let's say it. Here's the question. and not now decided whether the motor vehicle law of Maryland so discriminates against residents of the District of Columbia as to be unconstitutional denial of equal protection of the laws in that respect. This court will assume, in the absence of a definite and authoritative ruling of the courts of the state to be contrary, that when a statute shall be construed by the highest court, discrimination against residents of a particular state or territory will be denied. The movement of motor vehicles over highways being attended by constant and serious dangers to the public and also being abnormally destructive to the highways is a proper subject of police regulation by the state. In the absence of national legislation covering the subject, a state may prescribe uniform regulations necessary for safety and in order in respect to operation of motor vehicles on its highways, including those moving in interstate commerce, including a reasonable graduated license fee or motor vehicles when imposed on those engaged in interstate commerce does not constitute a direct and material burden on such commerce and render the act imposing such a fee void under the Commerce Clause of the federal Constitution. Why are they talking about that? Because the first thing the Supreme Court doing is you're saying this is unconstitutional. Well, the only thing that can be unconstitutional about interstate travel is whether or not this materially affects the interstate, the clause under the Constitution, which is Article 1, Section 8, Clause 3. It does not. That's what they're saying. So it's not a federal question. It's solely a state question. A state may require registration of motor vehicles, and a reasonable license fee is not unconstitutional as denial of equal protection of the laws because graduated according to the horsepower of the engine. Such a classification is reasonable. The reasonableness of the state, now notice we keep talking about reasonable. The reasonableness of the state's action is always subject to inquiry insofar as it affects interstate commerce. And in that regard, it is likewise subordinate to the will of Congress. Is this a question of interstate commerce? That's the only question that the judges are looking at right now, because if it's not, it don't have anything, it's not anything to do with the federal Constitution. It goes on. A state which, at its own expense, furnishes special facilities for the use of those engaged in interstate and intrastate commerce. Interstate means between states. Intrastate means in the state. For those who, who don't understand, may exact compensation, therefore, and if the charges are reasonable and uniform, they constitute no burden on interstate commerce. What they're saying here, okay, is charging a fee for registration and license a burden on interstate commerce? The action of the state is, in such respect, must be treated as correct unless the contrary is made to appear. A state motor vehicle law imposing reasonable license fees on motors, including those on non-residents, does not interfere with rights of citizens of the United States to pass through a state. Okay, the facts which involve the construction and constitutionality of certain provisions of the motor vehicle law of Maryland and their application to citizens of the District of Columbia are stated in the opinion. Mr. Jefferson Reynolds delivered the opinion of the court, because we got some people, they just coming in, making these arguments that we've already talked about, and that just goes to show their intelligence. They late to the party and don't see that we just spent about an hour talking about this bullshit that you're saying. Plaintiff in error was tried before a justice of the peace in Prince George's County, Maryland, up on a charge of violating the motor vehicle law. A written motion to quash the warrant because of a conflict between the statute and the Constitution of the United States was denied. He was found guilty and fined. Thereupon, an appeal was taken to the circuit court, the highest in the state having jurisdiction, where the cause stood for trial de novo. De novo means anew, which means they relitigated the case over on the appellate level. Well, the cause stood for trial de novo upon the original papers. It was there submitted for determination by the court upon an agreed statement of facts, grievously verbose, but in substance as follows. Very wordy and verbose paper, but they're going to condense it for us in substance of what it was generally talking about. The cause was originally brought on July 27, 1910, before a justice of the peace for Prince George's County by the state against John T. Hendrick for violating subsection 133 of the motor vehicle law effective July 1st, 1910. He is and then was a citizen of the United States, resident and commerant in the District of Columbia. On that day, he left his office in Washington in his own automobile and drove, notice his own automobile, we ain't talking about nothing commercial, and drove it to Prince George's County. And while temporarily there, he was arrested on the charge of operating it upon the highways without having procured the certificate of registration required by subsection 133 of the motor vehicle law. He was brought before a justice of the peace and fined $15, and having been found guilty of the charge, set out in a warrant duly issued, a motion to quash having been denied. whereupon he filed his appeal. At the time and place aforesaid, he had not procured. Now notice this right here. He's going to appeal, but he had not procured the certificate of registration for his automobile required by subsection 133. Upon the foregoing, the court shall determine the question and the differences between the parties and render judgment according to their rights in law may appear in the same manner as if the facts aforesaid were proven upon trial. Either party may appeal. In other words, we're gonna relitigate this, and you can appeal it if you want to, just as if you had done it on the lower court. The Maryland legislature, by an act effective July 1st, 1910, prescribed a comprehensive scheme for licensing and regulating motor vehicles. The following summary sufficiently indicates its provisions. The governor shall appoint a commissioner of motor vehicles with power to designate assistants who shall secure enforcement of the statute. Before any motor vehicle is operated upon the highways, any motor vehicle is operated upon the highways, the owner shall make a statement to the commissioner and procure a certificate of registration. Thereafter, it shall bear a numbered plate. The certificate and plate shall be evidence of authority for operating the machine during the current year. Registration fees are fixed according to horsepower. $6 when 20 or less, $12 when 20, from 20 to 40, and $18 in excess of 40. They still do the same thing today. According to the horsepower of your car, you're going to register, you're going to pay your fee according to the horsepower of your car, how big it is, because it puts wear and tear on the roads, okay? All right? And they were doing the same thing back then that they do today. When you go to another city, like when I came from Atlanta to Dallas, I got Georgia tags on. They say, okay, you got 30 days to get those tags off your car. We'll let you drive here for 30 days, use our roads without registering anything. But after that 30 days, you're going to have to get registration because you're using our roads in this city that the people of this city pay for. And you got to put some money in the kitty and pay for its use as well. Registration is for use of the roads. And license is to make sure that you're competent in the operation of that motor vehicle. Now, could that be accomplished with something outside of a license? Yeah, but I see what they're saying. It's a public road. You don't have no right to use it. It is a benefit and a privilege. If it's a public road, it's not a private road. It's a public road. So it goes on, any owner or operator of an automobile, non-resident of Maryland, who has complied with the laws of the state in which he resides, and this right here just going through the registration. All right, this is just a state statute. All right, we don't need to talk about that. Let's get down here with a judge. He's going to tell you what all this means. Plaintiff in error maintains that the act is void because it discriminates against residents of the District of Columbia, attempts to regulate interstate commerce, violates the rights of citizens of the United States to pass into and through the state, exacts a tax for revenue, not mere compensation for the use of facilities, not mere compensation for use of facilities. All right, they're trying to say that you're charging for other things other than just for the use of the road. Okay, according to arbitrary classification and therefore deprive citizens of the United States of the equal protection of the laws. If the statute is otherwise valid, the alleged discrimination against residents of the District of Columbia is not adequate ground for us now to declare it altogether bad. Now, why is it this law is good for every other state, but it didn't apply for the District of Columbia? If you are a resident of the District of Columbia, it doesn't matter. You have to, when you come in here, you got to get a tag for your car. We're not giving you that. All right, you got to get, it don't apply to you. Everybody else, this exception applies to. Except, and that's what he's talking about, that you're discriminating against. But the reason I believe they're doing that because District of Columbia is not a state. And that's why it wasn't included in this. All right, so it goes on, it says, if the statute is otherwise valid, the alleged discrimination against residents of the District of Columbia is not adequate ground for us now to declare it altogether bad. At most, they are entitled to equality of treatment, and in the absence of some definite and authoritative ruling by the courts of the state, we will not assume that, upon a proper showing, this will be denied. The record fails to disclose that Hendrick had complied with the laws in force within the District of Columbia in respect of registering motor vehicles and license operators, or that he applied to the Maryland Commissioner for identifying tag or marker, prerequisites to a limited use of the highways without cost by residents of other states under the plain terms of subsection 148. In other words, like here in Georgia, okay, if I leave Atlanta and come to Dallas, okay, they'll let me slide as long as I got my license and I got my registration in Atlanta. I get to slide for 30 days. Same thing was happening back then. But after 30 days, they want, hey, look, you got to get a registration for this state. Same thing right there. He cannot therefore set up a claim of discrimination in this particular. Only those whose rights are directly affected can properly question the constitutionality of a state statute. In other words, you can't blame a blanket claim for everybody. You have to identify how you were injured. Okay? You can't come into the court and file some lawsuit for all the people of the United States of America, or for you and your boys, or the people in a city. It got to be for you. How are you injured in this? It goes on. The movement of motor vehicles over the highways is attended by constant and serious dangers to the public, and is also abnormally destructive to the ways themselves. In other words, there's a public safety issue. Also, there's wear and tear on the roads. Their success depends on good roads, the construction and maintenance of which are exceedingly expensive, and in recent years, insistent demands have been made upon the states for better facilities, especially by the ever-increasing number of those who own such vehicles. As is well known, in order to meet the demands and accommodate the growing traffic, the state of Maryland has built and is maintaining a system of improved roadways, primarily for the enforcement of good order and the protection of those within its own jurisdiction. The state put into effect the above described general regulations, including requirements for registration and licenses. As a further evident purpose was to secure some compensation for the use of facilities provided at great cost for the class of those whose needs they are essential and whose operations over them are peculiarly injurious. In other words, we're getting this money for you because you demanded good roads. You got to pay for them. That's coming out of your pocket, and that's what the registration and the licensing fees are for. In absence of national legislation covering the subject, all right, there is no federal law on this topic. A state may rightfully prescribe uniform regulations necessary for public safety and order in respect to the operation upon its highways of all motor vehicles, those moving in interstate commerce as well as others. That sentence kills every fucking thing each one of you are saying in the chat. If you don't understand this, you are illiterate. In a discussion, you're illiterate. And I done read this whole case. I've read it. Go back and watch it over again. I've read the whole case. No AI. I don't need AI to understand this. Let's run it through AI. Let's see what AI said, because they're going to say the AI lied to you. Let's see if the AI agrees with me. Give me a breakdown of this case. People are watching. Let's look at this real quick. Hendrick versus Maryland. Oh, shoot. Sorry about that, y'all. All right, let me just put this on the screen, man. Y'all don't need to look at me. Let me put this on the screen. I don't even need to be on the screen. Put this on the screen. Y'all just see the whole thing. I don't even need to be on the screen. All right. So I uploaded Hendrick versus Maryland. Here's a clean live show breakdown of Hendrick versus Maryland. What happened? John T. Hendrick was a resident of Washington, D.C. He drove his own automobile into Prince George's County, Maryland, and was arrested because he had not registered the automobile under Maryland law. He was convicted and fined $15. Maryland statute required a registration of the vehicle, a numbered plate, an operator's license, and payment of license fees. The registration fees varied according to horsepower, and the operator's license cost $2. So this was not abstract constitutional case. Hendrick literally drove into Maryland without complying with the motor vehicle law and challenged the law itself. What did Hendrick argue? He made several constitutional arguments. He claimed Maryland's law discriminated against residents of the District of Columbia, improperly regulated interstate commerce, interfered with the right of citizens of the United States to pass through a state, imposed an improper revenue tax, and denied equal protection. That makes this case extremely useful for the right to travel debate because the Supreme Court directly confronted the arguments that vehicle license interfered with interstate commerce, which they said it did. What did the Supreme Court hold? The Supreme Court upheld Maryland's law. The central holding is this: states may reasonably regulate the operation of motor vehicles on public highways. The court explained that motor vehicles presented constant and serious dangers to the public and caused unusual wear to the highways. Because of that, regulation under the state's police power was legitimate. Then comes the language everyone discussing the right to travel needs to understand. The court said the state may require vehicle registration, driver's license, reasonable fees, and uniform safety regulations, even when the vehicle is engaged in interstate commerce. That is the holding. Does Hendrick, it says even if it's engaged, not just if it's engaged in commerce, also in addition to commerce. This is what I mean when I say that you are illiterate. A lot of you are illiterate. Y'all can't read. I know that may make some people mad when I say that, but I'm sorry. It's like that's what I'm seeing. This is just what I see. I just see a lot of people who cannot read. I'm like, you can't read, man. You can't read. You get mad all you want. Go make a video. All you want, do whatever you want. I'm telling you what it is. All right. So it goes on. Does Hendrick say there is no right to travel? No. This is one of the most important distinctions for your audience. The court did not say there is no constitutional right to travel. Instead, the court rejected the argument that Maryland's particular motor vehicle regulations improperly burden that right. The court distinguished Crandall versus Nevada, where Nevada imposed a direct tax on people merely for leaving the state. The Supreme, okay, they just leaving it, they got taxed just for leaving the state, no matter what mode of travel they were in. That was not an automobile case. The court distinguished Crandall versus Nevada, where Nevada imposed a direct tax on people merely for leaving the state. That was unconstitutional. The Supreme Court explained that Maryland was doing something materially different. It was regulating the operation of dangerous machines on highways and charging for facilities supplied by the state. That distinction is critical. Crandall taxing the person simply because he travels. Hendrick regulating the machine and manner by which the person travels. Those are not the same thing. This is where a lot of sovereign citizen arguments fail. A person may say travel is a right, therefore the state cannot require me to obtain a driver's license. Hendrick rejects that inference. Even assuming a constitutional right of interstate movement, the court held that reasonable regulation of automobiles remains permissible. Now, this is a Supreme Court decision, one that y'all quote a lot, misquote a lot, because you don't read the case. You do a cursory overview of it without reading it, and then draw conclusions on it. So I don't know what else to tell you. I really don't know what else to tell you on this. All these cases read the same way. You can put Thompson versus Smith. I was going to do that one next. All of them talk about they have a right to regulation. You have a right to travel. You do not have a right to travel unregulated. You have a right to travel. You do not have a right to travel, and it don't have anything to do with commerce, whether you're operating in commerce or not, just by the use of the public roads, because it doesn't matter. All cars put wear and tear on the road, whether you're operating in commerce or not. And all cars pose a threat to pose public safety, whether you're operating in commerce or not. Now, I can't help you understand that. If you can't understand what these cases, this ain't no AI or don't need AI or anything like that. You are just illiterate, and you need to deal with that. You're illiterate. I don't know what else to tell you. And he got talking about the Dred Scott decision. What does that got to do with operating with public safety? That don't have nothing to do with public safety. The 14th Amendment or nothing. None of that has anything to do with the public safety. None of that. None of that. That has nothing to do with public safety. Maryland, look at that, Maryland and state of Maryland. Okay, y'all keep making them arguments. Keep making them stupid ass arguments. You want me to start doing, let's look at some right to travel cases real quick. Since y'all wanna, let's see how people are faring out there using this ideology that you're talking about. Let's see about this right to travel, all right? Let's look at this real quick. Right to travel, right to travel. All right, let's look at it real quick. They claim you got a right to travel. I mean, well, they claim you got a right to travel without a driver's license. Let's make it in. They say you don't need a license, you don't need a registration. All right, so here we go. All right, so we got 1 million cases. Right to travel destroyed. Right to travel. We have our own government on. Let's look at this one right here. We have our own government online.
I'm telling you.
Let's look at this real quick.
Because what follows is a mix of confusion, courage, and courtroom-ready drama. Trust me, you'll want to watch every second.
I do have my all my information right here.
Okay. Do you mind if I see that?
Yes. And I also have my Moorish. Well, it should be right there. All right there. Yeah, it's all right there.
Have you ever had an Ohio ID before?
I don't contract with the state of Ohio.
So have you ever had an Ohio ID before?
No, I don't contract with it.
Okay. All right, give me 1 second. 1640.
Go ahead.
Yeah, this is a sovereign citizen. I don't know if you want to head up here. I'm sure they're going to request the boss at some point.
John 4.
They already know what y'all gonna do.
Yes, ma'am.
Also, my right to travel. That's also notarized and it's notarized and it's filed with the state of Ohio.
Okay.
It's an affidavit of my right to travel.
What is your first name?
Asada.
Okay. And then your last name is Bay?
Yes, it is.
Okay. You said 223 Run Street?
That's my address on there. You can't just you can take that out of your pocket.
I'm not taking it. I'm just holding it so my hands are free. That's it.
Oh, okay.
Right.
So I'm on my way somewhere that's very important.
Okay.
And you kind of holding me up.
Oh, don't worry. Gate, you can see the tension building. Officer Douglas approaches calmly, asking for basic info, license, registration, vehicle identification. But she's ready with her Moorish American documentation, declaring she doesn't contract with the state of Ohio. Notice how she uses legal-sounding terms like domicile, even if misapplied, to try to legitimize her stance. This is classic sovereign citizen behavior, mixing real legal references with personal interpretation. The drama here isn't just about law, it's about power dynamics. Watch how her confidence contrasts with the officer's patience, setting the stage for an epic showdown that keeps everyone on edge.
I don't know what that is.
It's a fee schedule for if I'm bothered in my private mode of travel. So this is a notice of intent fee schedule. And so this is for any and everything that you may have going to pull me over for, or anything that you may keep me on the side of the road for.
It's called a fee schedule?
Yes, it is a fee schedule.
Here, can I take a look at the first? Oh, I'm sorry. The first one on the fee schedule? Yeah.
Mm-hmm.
Okay. All right. Well, just hang tight, okay?
Well, listen.
What's up?
Can I have my ID back
Yeah, you're welcome to.
so I can go?
You're not free to leave
Why?
because you're being detained.
Detained?
Yeah, it's a traffic stop. You're detained. You're not in handcuffs or anything like that. But
This is unlawful detainment.
it's not,
It
okay?
is unlawful
I know you believe it
detainment.
is, but I've done this plenty of times, okay?
Okay, well, I also have the right to travel
Okay.
in my private
May I
mode
see that?
of transportation. It's my private mode of transportation.
May I see that? Here, you want to trade? I'll give you this back.
No, you cannot.
Oh, okay. All right. Well, just like I said, you're not free to go, okay? So just hang out for 1 second, all right? What's up, Chief? Sovereign citizen. Moorish American.
How those in a while?
I think I got a real info though off a paper that she showed me. Dominique Cattell,
On Run Street.
allegedly. She doesn't live there. She's, I don't know what the word she said.
Docimile.
She has a fee schedule for any time she's stopped by law enforcement and bothered.
Fee schedule.
Yeah,
Where are you on show?
Fee schedule. So we should charge her for every time
No.
she charges us.
she charges us. She just has no business with the state of Ohio, but she has allegedly an affidavit signed by the state of Ohio. saying that she's allowed to travel. I just figure I've dealt with sovereign citizens before,
Right.
and that's what I asked her. I was like, "Oh, are you Moorish American?"
But you still gotta identify yourself is the problem, and that's where that's where the hook will be. That's usually where these things go south.
Yeah. What was your name before it was Bay?
My name is Asada L Star Bay. That's all. The old name does not matter. So this is my name. This is my name, and this is
To travel affidavit and a fee schedule for any interactions with law enforcement. This is peak sovereign citizen theatrics. Think about it. She's essentially telling the officer, if you stop me, you owe me money.
As the founder of Pulsetto,
The tension is palpable because Officer Douglas isn't having it, yet he remains professional, calmly explaining the realities of the law.
Much larger. And instead of letting perfectly built devices sit in our warehouse, I would rather see them helping real people sleep better, reduce stress, and feel more
If it's never been registered in the state of Ohio, it's never going to come back to a state of Ohio license plate, and therefore it won't be registered to you or anyone else. Does that make sense?
Start a program with the app and go.
No,
It's
it was
lightweight, adjustable, and sessions.
In Ohio or through the Moorish name?
Created it for people who want real nervous system
when I
support
bought
without
it because I
disrupting their
had to
daily
register it
routine.
here
And the
when I
messages we
bought it.
receive
Did they give you a
every day
temporary
are the reason we
tag?
continue
Yes, and
doing
it
this.
expired.
Normally,
Okay.
devices in this
Once it
category cost
expired,
hundreds more. But
I
because we
never got
overproduced this
anything
latest
else
batch, we're
because
releasing these
I do
Pulsetto
not
units at a
contract with the
temporary
state of
discounted price.
Ohio
Same exact
to get a
device,
license.
Same exact
I'm not trying to be
just a better
difficult.
opportunity
This is
for you.
just
Once
what
this
I'm,
inventory
you
is
know,
gone,
this is
pricing
who I
won't be
am.
available
I
this
don't
month.
go by the
Now
old
is a very
name
good time.
anymore.
Check
I'm
below
not a
to see if the
murderer.
discounted units are still available. And thank you for
The sheriff says having a flock camera like this one is just like if a deputy was standing on the side of the road with a camera.
Come step right back here. What did you take out of it?
Nothing. I was
Okay. All right, listen. Just come back here. I think we're getting off on the wrong foot, okay?
Because I'm really confused on why I'm getting
He's
stopped.
got several warrants.
Okay, that has nothing to do with me.
You don't know who's in the car.
Nobody's in my car.
Well, now,
Okay, so we got.
put the gun down! Put the gun down! Come step right back here. What did you take out of it?
Nothing. I was
Okay. All right, listen. Just come back here. I think we're getting off on the wrong foot, okay?
Because I'm really confused on why I'm getting
He's
stopped.
got several warrants.
Okay, that has nothing to do with me.
You don't know who's in the car.
Nobody's in my car.
Well, now I know that. However, now I'm going to address the other problems.
Okay, so you want my bag and all my belongings.
So just step right back here
Can I use the restroom?
and let you know there's being audio and video recorded.
That's
Just to let you know.
Okay.
Here, do me a favor, sir.
No, hold
Turn
on.
around.
Don't put me in handcuffs. I haven't done anything wrong.
Ma'am.
No, don't put me
You're about to get paid. Get down! Get down on the ground! Down on the ground!
I didn't do nothing.
Step out! Ma'am! Put the gun down! Put the gun down! 22 shots fired! Shots fired!
10-4, 13, keep out that code 3.
23, I'm hit. Put the gun down! Come step right back here. What did you take out of it?
Nothing. I was
Okay. All right, listen. Just come back here. I think we're getting off on the wrong foot, okay?
Because I'm really confused on why I'm getting
He's
stopped.
got several warrants.
Okay, that has nothing to do with me.
You don't know who's in the car.
Nobody's in my car.
Well, now I know that. However, now I'm going
Okay. This is just one example I dug up. I got a lot more. This is what that foolishness, that's what y'all doing with that right to travel. You got people, this is why I do these things, because I'm sitting here, y'all don't monitor what's going on, because in the echo chambers, y'all don't watch any of this. You know, y'all just go around and spew y'all stupidity all day long. And there are a lot of people that are absorbing it. They're out shooting people. That's like what, the third or fourth incident. They're going to start classifying y'all as terrorists, and they're going to start fucking y'all up. It's coming, I'm telling you. And the stupidity that I see demonstrated by stuff like this, you want me to talk to these other people? I don't need to talk to no other guru on the internet about this shit. I can read it myself. What the fuck you want me to talk to them about? You want me to talk to some illiterate motherfucker who can't read what's right there in front of his face? Hey, y'all need to get out of here, man. You should and want to know if some works, try it yourself. But you need to make sure you're in the right and you understand what you read. Don't try nothing and you don't understand what you read. This right to travel stuff is some bullshit. I'm telling you. Y'all getting people injured and locked up with this dumbass shit. You are out there following people. I guarantee you, these people in high school, they couldn't read on the damn sixth grade level. All of a sudden, they're out here on the street now they guru this and guru that. Get them, like you telling me, I'm talking about AI, get them to get on the internet and read this case from beginning to end and see if they can break it down like that. Talk about somebody depending on AI. I don't need no goddamn AI to understand this shit. This is simple. And if you don't understand it, there's something wrong with you. The Supreme Court ain't never asked for no consent on regulations, fool. That's police power. Show me a case right there that substantiates what the Supreme Court almost always asks if there was consent. Pull the case. If not, shut up. Because you ain't seen the Supreme Court say none of that. Because if you had, you would have put the citation of authority in there. And you're not going to do it on me because you know I'll pull that shit up and demonstrate to the world just how illiterate you are. Look at this stuff, right? I just read these people a Supreme Court case, and they thinking they gonna put some statutes and things that's gonna supersede that. That right there just gonna be show how stupid y'all are right there. I just read Hendrick versus Maryland is a Supreme Court case, fool. Y'all understand? Do you understand when somebody says Supreme Court? Do you understand what that means? You can't go and get codes and statutes to supersede that. All right? You can't, there's nothing that you're going to pull that's going to supersede that, idiot. Courts do make law. Courts make law that get it. What are you talking about? Courts don't make law. Hey, y'all, I want y'all to see these are terrorists. This is why they call them terrorists. Look at what they're saying in the chat. This is why I can't be a part of them. Because these are illiterate terrorists. Illiterate. They just want to be right. They don't take no accountability. They just want to be right. They ain't trying to understand the law or nothing. They ain't trying to understand this or nothing. I'm trying to tell you, follow these people at your peril. I'm trying to tell y'all, you follow them we can go on the internet. I can show you, there's probably 1,000 videos on you. All you gotta do is put in sovereign citizen right to travel fail. Everybody listen to me right now. Put in sovereign citizen right to travel fail and just spend a day just watching those videos. You ain't got to listen to nothing they say. Just spend a day watching those videos and then start reading those cases yourself. Copy the case, upload it into your AI and tell your AI to give you the breakdown of the case. You don't need to listen to them. That's why I read the case before I put it in the AI, because these fools, they'll start talking, well, you depend on AI. I read this case before AI came out. You need AI. You need it. You need AI. You need it. The Dred Scott case don't have shit to do with this, is what I'm saying, fool. I ain't saying get mad, you bring it up, don't have nothing to do with this. It don't have nothing to do with status. Right to travel has nothing to do with status. It don't have nothing to do with declarations. It has something to do with public safety and police powers. So I'm not mad you brought it up. I'm just telling you, you don't understand the law. Because what you're saying has nothing to do with this. I see why. Hey, listen, man, I'm through with it. This is going to be my last right to travel review. After this, you can do what you want to do. But I'm just sorry. As an intelligent person, I consider myself very intelligent with exceptional comprehension skills when it comes to reading things. And this is not very difficult to read. And I guarantee you that every person that quotes it, not a single one of them read the case. They just picked and choose something out of it, didn't put it in its proper context or anything like that, and then come and gave it to you and said, well, this only applies to commercial matters. And it does not say that. It says it applies to everybody that's on the public roads. All right, you're required to have a license and be registered. Okay, it don't say that. You can pull up Dred Scott decision all you want. If you want to pull up the Dred Scott decision, then you need to then you need to try to get it before the Supreme Court and argue that shit. All right, but you ain't got nothing on the books to substantiate nothing about the 14th Amendment and Dred Scott and none of that bullshit that you're talking about, because it don't have anything to do with this. Because you don't understand law. You think there's some status thing. It don't have nothing to do with status. It don't have nothing to do with status. It's public safety and police powers. Why don't you go and try to study that? You know why you want? One thing I notice about y'all won't study anything that goes contrary to what y'all believe. You want to go with a belief or your own interpretation of something that don't have no basis in law or fact. Because you're not even competent enough to be trying to interpret these statutes. You're not even competent enough to I see what y'all reading level is at. Your reading level, you got to admit it to yourself. Your reading level is not on a level. You're going to go up against attorneys. Like we got Juan Galt in the audience. He's an attorney that's argued before the Supreme Court. He probably has a vocabulary. I don't know. I'm just throwing words. I'm just using this for illustrative purpose. He probably got a vocabulary of 7,500 words. Most of y'all got a vocabulary probably 1,500 words. 2,000 words probably best. I guarantee you, most of y'all in this chat, y'all don't have a vocabulary that exceeds 1,500 words. That's what I'm saying. It's like even a visitor from another country has to follow. I rented cars in other countries. They want to see my driver's license, and I will get a ticket. I will get pulled over. And me saying I am an American citizen don't mean shit, okay? Don't mean a damn thing. Likewise, when somebody else from another country comes to the United States of America and they get pulled over, they ain't gonna say, I'm not a U.S. citizen. I wasn't operating in commerce. It don't matter. This is my thing. Are you saying that everybody in the country don't have to follow traffic laws? Is that what y'all are saying? Y'all saying that every single person, all 300 million people in the United States of America, we can drive whatever speed we want. We don't have to stop at stop signs. We don't have to stop at traffic lights. And when we violate one of those laws, a police officer can't pull us over because they don't got jurisdiction over you. Does that make sense? Anyway, that's all I wanted to talk about. I'm out. I'll get y'all on the next one. I got some other stuff I got to do. I don't have time to be talking about right to travel all day. You read it. You do whatever you want to do. All right. I'm telling you what my position is. All right. You like those flat earthers. All right. You're just like them. They got the same level of reason and rationale. A whole bunch of retards and everything. And that's what I see from this. This is a bunch of retards. This is retarded, man. This is retarded. It's not even intellectual. It don't even rise to the level of being intellectual discussion. That's how clear it is.